talk about some of the, thank you, talk about some of the facts of the case, broader implications of the case. So today we have Associate Dean Jonathan Witmer-Rich. He's going to be talking about the facts of the raid, analyzing whether it violated the Fourth Amendment, and the criminal charges that could have or should have been brought. And then we have Professor Reginald O, who will discuss the broader implications of the raid, such as mass incarceration, systemic racism, and potential solutions to each. So without further ado, I'm going to have them each introduce themselves. We can get started.
Okay, great, thank you. So I'm Jonathan Witmer-Rich. I'm a professor and associate dean here, and I teach criminal law and criminal procedure, so I'm going to focus on that part of the discussion.
I'm Professor Reginald O, and I teach constitutional law and write about constitutional law, and I've written a lot about race and law, and so we'll, like Tayler said, I will talk about some of the broader implications dealing with race and systemic racism implicated by what happened to Breonna Taylor.
Okay, so I'm going to get started here. The case kind of begins with an investigation by Louisville police into other individuals. Let me pull up my into some other individuals. Jamarcus Glover and Adrian Walker. And they basically, throughout the month of January, developed probable cause that they were dealing drugs out of a house at 2424 Elliott Avenue, and that they maybe were using a particular car and so forth. And so in March, they filed, they obtained search warrants for those locations, but also for a different location, the location at 3003 Springfield Drive, apartment number 4, which was Breonna Taylor's apartment. And so the affidavit that they filed that gave rise to the warrant to search her home and these other locations mainly talks about 2424 Elliott Avenue. It talks about the Adrian Walker and Jamarcus Glover and their behavior that maybe gives rise to some suspicion of drug activity. And then it connects it to some degree with 3003 Springfield Drive, apartment number 4. And basically the claim here is that they had observed Jamarcus Glover go there on one occasion and leave with a package. And they had confirmed from the U.S. Postal Inspector that Jamarcus Glover had been receiving packages at that address. Now there's evidence that's come out since the case that that in fact was not true, that the postal inspectors have said that in the months leading up to this, there were not packages being delivered to Jamarcus Glover at that. So there's a big question about that particular fact in the affidavit, which is one of the key facts connecting Breonna Taylor's residence to this set of searches. But in any event, the police also requested authority to do a no-knock search. The affidavit stated that they are requesting a no-knock entry due to the nature of how these drug traffickers operate. They have a history of attempting to destroy evidence, have cameras on the location that compromise detectives once approach to the dwelling is made, and have a history of fleeing from law enforcement. So it's a pretty conclusory statement, and it pretty clearly is talking about 2424 Elliott Street and about these other individuals. And so it's not clear that this statement has anything to do with Breonna Taylor's apartment. And in any event, one particularly notable thing about the case is that every account I've ever seen of this talks about this as a no-knock warrant, but the warrant itself does not say anything about no-knock authority. The officers request that authority in the affidavit, but the warrant, which is a separate document, does not say anything about you have authority to enter without knocking and announcing. So in my view, and the view of some other criminal law professors I've talked to, this is not a no-knock warrant. It's a warrant that was requested to be no knock, but was not granted that way. And in any event, that takes us up to kind of how this warrant was executed. So I'm going to go off just briefly on a tangent, I guess. And so I wonder if any of you have ever been woken in the middle of the night by somebody pounding on the door to your house. I don't know if you've had that experience or not. I had that experience once. I was down in Charleston, West Virginia. I was living in an apartment on the second floor. You could get to the second floor door by going up an exterior stairs. And in the middle of the night, I was woken up one night by somebody pounding loudly on the window. And it's a unique combination of confusion because you're asleep and you have no idea what's going on, and terror because you have adrenaline rushing into your system, and immediately you're trying to figure out what's going on. It was deeply terrifying. It turned out it was my next door neighbor who was drunk and had locked himself out of his house, and which I couldn't help him with, but I told him to go away and he went away. But that's, that was fine, and nothing bad happened to me, but it was terrifying. The common law, I'm going to switch to the common law now. The common law has two rules that were specifically designed with that problem in mind, right? When people are awoken in the middle of the night and people bust into your house without you knowing who they are, that's terrifying, and it's very likely to lead to violence, right? And so at common law, there were two rules. One of them goes back to at least 1603, right? So it's over 400 years old, and it's called the knock and announce rule. And really what it says is, if police are executing a warrant, before they break open the door, they need to announce their presence. The case says the officer ought to signify the cause of his coming and to make a request to open the doors. The party has to have notice that the officer cometh not as a mere trespasser, but claims to act under a proper authority. So the key here is not the knock itself. It's really conveying in whatever appropriate manner to the occupants that the person outside is a police officer and they're there executing a warrant, and they would like you to please open the door before you break the door open and cause the unnecessary damage to the door, and before you alarm the people inside the house. An 1819 British case could easily be describing the reaction of Kenneth Walker, Breonna Taylor's boyfriend, who fired a shot after police entered his house. The case says, if the police do not announce themselves before they enter, quote, how is it possible for a party to know what the object of the person breaking open the door may be? He has a right to resist, a right to consider it as an aggression on his private property, which he will be justified in resisting to the utmost. So the court there is talking about how obviously if someone breaks into your house, the occupant has a right to resist that entry, and that is the purpose of the knock and announce principle. Going right along with that, kind of hand in hand, is the daytime entry rule. The common law, again, an ancient common law rule that says when executing a warrant, the police must execute them during the daytime, not at night, for very similar reasons. At night is when people are in their homes, they're often asleep, and a sudden intrusion at night is even more alarming than an intrusion during the day, when you can see what's going on and when people come and go more commonly. So again, by the time that the Fourth Amendment was passed in 1791, 12 of the 13 states already had rules that barred nocturnal searches, right? And both of these rules, the knock and announce rule and the daytime entry rule, they did have exceptions where you could justify dispensing with knock and announce or entering at nighttime. But the presumption was you have to execute the warrant during the day, and you have to knock and announce and give the occupants notice and a reason, ability to come and open the door. Those rules kind of precisely describe, unfortunately, the disaster that happened in Breonna Taylor's case, where the police It's disputed whether they did knock. One neighbor, the officer said they did knock ahead of time. One neighbor says he's given conflicting accounts. At times he said he heard them knock. At other times he said he didn't hear them knock. 11 other neighbors said they did not hear a knock. But in any event, the warrant was executed at 12:40 a.m. in the middle of the night. And so even if they did knock, if they're observing the knock and announce rule, they need to knock and wait a sufficient period of time for the occupants to wake up, figure out what's going on, come to the door, and have an opportunity to open it for the officers. And I think it's very clear that they did not do that, whatever they did, right? They did not do that. And so to me, it's a pretty easy case to make out that the police did not follow the knock and announce rule. They did not follow the daytime entry rule, and they did not have sufficient reason to deviate from those rules in this case. The warrant kind of makes conclusory assertions about drug dealers getting rid of drugs and so forth. But again, those, if they're true, were clearly describing the other residents. There was no reason to think that if there were drugs or proceeds being stored at this residence, that somehow there was an emergency, that there were hardened drug dealers at this location, anything like that. So I think a very strong case can be made for a violation of the Fourth Amendment in the way this warrant was executed. So I'm going to turn to criminal charges in just a minute, but very briefly, why would the police kind of violate those provisions, maybe in a somewhat cavalier fashion? And I would say part of the reason is that the Supreme Court, while they recognized in 1995 that the knock and announce rule is part of the Fourth Amendment, it's not just a common law rule, it's part of the Fourth Amendment. But then a couple years later in Hudson versus Michigan, they announced, but we are not going to apply the exclusionary rule to violations of the Fourth Amendment. So even if you violate the knock and announce rule, the evidence will still come in. And the result of that is that we have very few cases telling us what the knock and announce rule really means, because there's no point in litigating it. Even if you prove that they violated the knock and announce rule, you don't get suppression of the evidence. So I think it's become a rule that's there in some senses only on paper, right? Finally, I want to turn to the potential issue of criminal charges. So the best place to start with this, really, and some of you may have seen this already, and if not, I recommend it to you. I will send it to you in the chat a little bit later when I'm not speaking, which is Professor Paul Butler at Georgetown, who's a former federal prosecutor, has released a video online. It's about 10 minutes long, and he's basically making the opening argument in the prosecution, the fictitious, of course, prosecution of these three officers. And he identifies two charges under Kentucky law that he would bring in this case. And those two charges are second-degree manslaughter and reckless homicide. And they're very similar charges. Second-degree manslaughter is based on wantonly causing the death of another, and wantonly under Kentucky law is defined in a manner that kind of talks about disregarding a substantial and unjustifiable risk that your conduct would result in death. And interestingly, Professor Butler, in his opening argument for the prosecution, does not focus on the knock and announce rule and the Fourth Amendment. He focuses on the way the police fired their weapons. And in particular, he focuses on how they broke into someone's house. The person fired one shot, which hit an officer in the leg. And the police responded by firing at least 20 shots. And the shots were all over the house in different rooms. And some of the shots were being fired from outside through a door. Some of them went into the neighboring residence. And so Professor Butler focuses on the manner of shooting being incredibly reckless, right? It wasn't, he argues, this wasn't a case of self-defense of one person firing and police firing in response, but rather one shot being fired and then police just opening fire recklessly on a large area. And so that really would be the essence of the criminal charges that he focuses on there. Second-degree manslaughter or reckless homicide, the idea of recklessly firing, right? The manner in which the police decided to fire. Now, again, the Kentucky Attorney General has investigated the case and is not filing any of those charges for the actual death of Breonna Taylor. I think that the federal government is also conducting a review of what happened then, but I think it's quite unlikely that any criminal charges will result from that. But of course, I guess that remains to be seen. So those are some of the key issues as I see them, and I'm going to stop now and turn it over to Professor O, and then I'm happy to, participate in the conversation as we have questions and comments later.
Okay, so as I mentioned at the beginning, I want to talk about the kind of broader issues implicated by the Breonna Taylor killing, murder, and want to suggest the main point is that a part of the outcry over her death is that it's not just a one-time thing. This was not an unusual situation occurrence. It's part of a larger pattern in American society and history of discriminatory policing, racial disparities in the criminal justice system, and systemic racism against African Americans, a racism that goes back centuries, okay? A strong historical root in this kind of racism. So what I want to talk about are what I think are the different kinds of racism that that's sparking the outrage regarding what happened to Breonna Taylor, and it implicates the experience of African Americans generally in American society. Okay, and part of this is about naming the harm. When we talk about discrimination, racism, what do we mean by it? And what's the harm involved? Okay, all right, so first, harm. I want to suggest that Breonna Taylor was killed for basically, quote unquote, existing while Black, okay? And this implicates what I call existential racism, where it's a racism where African Americans experience a constant threat and an undermining of their very being and existence. Okay, so it goes to the core of just being human, and this kind of racism is a threat to being human. Okay, so what do I mean by that? So I think people are aware of the recent spate of incidents where white people call the police on African Americans engaging in various conduct for engaging in completely normal, routine, everyday conduct. Okay, so I'll give you some examples, some recent examples. There are at Starbucks in Philadelphia, the Starbucks employees called the police because a couple of African-American men were hanging out at the Starbucks. Okay, that was the crime, hanging out while being Black, being at a coffee shop while Black, subjected the African-American men to arrest and potential criminal indictment. Okay, there's an incident where the police was called on African-Americans at a public park. Okay, and they were barbecuing while at the public park, and so basically, what was the crime committed by African Americans? Barbecuing while Black. Okay, and then an example where a white woman threatened to call the police on an African American bird watching at a park. Okay, and what I think there's a pattern to this, and it's the kind of the criminalization of everyday life. That's the racism that's at issue here. Okay, and for Breonna Taylor, right, she was at home. What was her crime that subjected her to to what happened to her in terms of her killing? She was at home. She was asleep. Okay, and unfortunately, right, that kind of situation where an African American is at home doing things you would normally do at home is not an unusual occurrence. So I'll give you two other similar examples that occurred within the last couple of years. The shooting and killing of Atiana Jefferson in Fort Worth, Texas, October 12th, 2019. A neighbor called the police using a non-emergency number saying her front door was open and they wanted the police to go check up on her. right, to see if she was doing okay. What ended up happening, the police shot her when she came out to the window and shot and killed her. And what was her crime, right? She was just at home looking out her window. Botham Jean, September 6, 2018, Dallas, Texas. Botham Jean was in his home eating ice cream when a police officer entered his door. It was unlocked, and shot him in the chest, thinking he was a burglar. And what happened was the police officer went into the wrong apartment, right? Went into his apartment thinking she was entering her apartment, thought he was a burglar, and shot and killed him. Okay. Again, he was eating ice cream, and then he was essentially murdered. Okay, so what? Atiana Jefferson, killed for being home while Black. Botham Jean, killed for eating ice cream at home while being Black. Breonna Taylor, killed for being home and asleep in bed while being Black. Okay, these are what I can call existential crimes against African Americans. Existential because your very existence is being threatened and undermined. Okay, the things you should be routine, is totally safe, right? Sleeping in bed, eating ice cream in bed, suddenly you're under constant threat. There's a feeling, there's lack of safety, lack of a constant feeling of being in danger. And it kind of forces African Americans to feel vigilant, hyper aware of one's surroundings, and a sense that you can't let your guard down because at any moment, some of these things could occur. Okay, and that lack of sense of safety generates what I call lack of a sense of belonging in society, and it infringes upon your ability to exist in the world free and unencumbered. Okay, and ultimately, I think this kind of racism implicates freedom. If you are not free to do everyday and routine things, where you're constantly under threat of having that everyday conduct criminalized, okay, to what extent are you truly free? Okay, and if you don't have that kind of freedom, the freedom to just be yourself, right, to feel safe in your home, okay, you're not really being given full humanity, personhood, full equal citizenship. Okay, and this is what I mean by existential racism, where, like I said, your very sense of your existence is constantly under threat, feeling like it's under threat, feeling like it's being undermined. Okay, and then another harm that arose out of the Breonna Taylor killing and other killings of African American by police officers, it's when African Americans are asked to and compelled to actually empathize with the police officer who engaged in the shooting. Okay, that when these murders occur, in terms of figuring out whether the police officers will be legally accountable through criminal law or through civil law for their conduct or actions, it determines whether they were acting reasonably under the circumstances. Okay, and determine reasonableness, whose perspective are jurors, the public, African Americans being asked to take the perspective of the police officers. Okay, so the law and society says, well, when these shootings occur, what was going on in the minds of the police officer, and was their conduct reasonable given the situation, given their conduct, given their perspective? Okay, did they use reasonable force? Okay, and then when oftentimes, right, when a situation involves dealing with potential criminals, potential perpetrators, it seems like almost everything from their perspective seems reasonable. So this is kind of a harm where people are asked to step in the shoes of the person who engaged in the harm and to kind of almost empathize from their perspective. Okay, and I think this is kind of a psychic racial harm, which is implicated in the concept of double consciousness, which I'm sure many of you are aware of, a concept that W.E.B. Du Bois came up with, and he called double consciousness a peculiar sensation, this double consciousness, this sense of always looking at oneself through the eyes of others, of measuring one's soul by the tape of a world that looks on in amused contempt and pity. Okay, so I think that's one of the harms whenever these situations occur, a police officer accused of shooting and killing or killing an African-American. It forces this kind of double consciousness among African Americans to look at yourself through how is the police officer, how's the white police officer looking at you, and then to privilege their point of view. Okay, I think that is a real psychic harm, racial harm, that these incidents always raise, because the law, right, requires us to look at the situation from the police officer's perspective. Okay, and then the third kind of racial harm is that all of this, what happened to Breonna Taylor, the ease with which the police officer sought the no-knock warrant, as Professor Witmer-Rich was talking about, and the kind of wanton recklessness that they engaged in when they just totally shot up her apartment and ended up shooting her multiple times, is the devaluation of Black lives, of African Americans' lives. And this is the Breonna Taylor killing, murder, George Floyd, what happened to George Floyd, all of that, right, reflects a devaluation of Black lives in American society, and particularly in and by the criminal justice system. Okay, and let me give you an example of what I mean by that in another context, which is, I think, implicated here. A case called, a Supreme Court decision called McCleskey versus Kemp, okay, which involved an equal protection challenge to the death penalty in Georgia. A Black defendant who was sentenced to death said his sentence violated equal protection because there were empirical studies showing that African-American defendants were much more likely to be subject to death based on their race. Okay, so that was the claim. And some of the statistics, these were some of the statistics found by the study, some of the findings. One, in death penalty cases, okay, in Georgia at this time, when in 70% of cases involving a white victim and Black defendant, the prosecutor sought the death penalty in 7% of the cases, okay? When the victim was Black and the defendant was white, the prosecutor sought the death penalty in 19% of the cases, okay? And a Black defendant charged with killing a white victim was 4.3 times more likely to receive the death penalty than a defendant charged with killing a Black victim. Okay, so two things going on here. One is whether you agree with the death penalty or not, when the prosecutor seeks the death penalty, it's making a statement about the value of the life that was extinguished and killed. What does it say when 70% of the cases involving a white victim and Black defendant, prosecutor seeks the death penalty, only 19% when the defendant or the victim is Black, the perpetrator is white? It's kind of what's the message being sent, right? The message being sent is Black lives don't quite matter as much as white lives, especially depending on the race of the perpetrator, the devaluation of Black lives. That was, I think, one takeaway from that case. And the other takeaway is that in that case, the equal protection challenge was rejected. That even though Black defendants had a much higher rate of being subjected to death, the equal protection challenge was rejected because the court said the defendant couldn't prove actual discrimination by the prosecutors and jurors in his particular case. Again, right, in McCleskey versus Kemp, they rejected the equal protection challenge because they took the perspective of the prosecutor, the jurors, and said, let's look at this situation from their perspective and see what they think. Okay, and that was given priority. And then one of the reasons, the dissent in this case raised this point about the majority. The majority in rejecting the claim, rejected it in part because if they said the death penalty was unconstitutional because of these disparities with respect to race, that would bring into question the death penalty in general, not in Georgia, but throughout the nation. Okay, and the majority did not want to go there. and the dissent said the majority feared too much justice. Okay, and this notion of fearing too much justice gets to, I think, one thing we should always think about when these killings occur. This is not just a one-time thing. This is part of a larger pattern, bigger context in which these incidents systematically continue to occur. Okay, and what's required is a lot of justice in these cases. Okay, and then the devaluation of Black lives. Why does that occur? Why does that happen? And this is the last point I want to make. The devaluation of Black lives is related to the systematic dehumanization, both historically and currently experienced by African Americans. It's dehumanization is a central process in systemic racism. And we need to talk more about the fact that the role that dehumanization plays in racism and in these shootings. Okay, what's dehumanization? It's fairly straightforward. The definition of dehumanization: it's the process of treating person or group of persons as less than human, as subhuman. Okay, it's treating people not like people. It's treating people in a way where you deny them human qualities. You don't think they're human. You deny them cognitive, mental, intellectual capacities. You deny them emotional qualities. And based on their physical appearance, you think that they don't have the appearance of being human. Okay, and the dehumanization often involves comparing the group to animals, vermin, diseases, insects, parasites, thinking of people as criminals, savages. People can't control themselves. Okay, and when people are dehumanized, what happens? There's a strong link between dehumanization and the infliction of violence, atrocities, and harm against the dehumanized group. There's a long historical link between dehumanization and the infliction of harm against people. A link between dehumanization and genocide. Okay, the classic example, the Holocaust and the genocide against Jews by the Nazi Germany. The Jews and Hitler thoroughly systematically dehumanized Jews, comparing them to diseases and vermin, not human, as savages, as people, as not people, as subhuman creatures who needed to be extinguished. Okay, and there are a lot of empirical studies showing the connection between dehumanization and the infliction of harm and violence. And here's the relevance, I think, to what's going on with African Americans and dehumanization of African Americans and all the police brutality and police shootings and killings and murder of African American civilians. Why does dehumanization lead people to harm the dehumanized group? And one of the key theories is the concept of moral disengagement. Okay, the theory of moral disengagement says, why do people not commit harm against other people? Because of their morality. Morality, moral principles saying you don't harm other people, that's immoral. Okay, the thing is, moral principles typically apply to other humans, human beings. Okay, so the theory about dehumanization is once you think of a person or group of people as less than human, as subhuman, except non-human, it turns off your moral constraints. Suddenly, the morality that you operate under when you interact with most people, it gets turned off. Okay, and when it gets turned off, suddenly it becomes easy to inflict cruelty and violence against other people. Your moral system is basically turned off, gone, and without that, that's when people engage in harm and violence against the group's been dehumanized. That I think, explains what happened with Breonna Taylor, the wanton and reckless shooting that occurred with Breonna Taylor's situation. Easy to do when you don't think of the person, right, that you're shooting at as fully human. You think instead of them as criminals, savages, people who are whatever, all these kinds of attributes where you deny them humanity and think of them as a constant threat. Okay, and I think that is often what's going on with these police with these police incidents, encounters with African Americans. And there is a really important article that was written a couple months ago that talks about how the police departments are actually trained to dehumanize people, specifically African Americans. It's an article written by David Brooks called "The Culture of Policing is Broken. Brutality and Dehumanization are Deeply Embedded in Many Police Departments." Okay, so do police officers, are they individual police officers randomly dehumanize people? No, this article argues that police officers are trained to dehumanize people, dehumanize them as criminals, as innate criminals who don't deserve treatment as full human beings. And then that often leads to the infliction of violence and these kinds of incidents with respect to police. And this is tied to the militarization of the police. There's a lot of studies showing that the more militarized the police department is, the more likely that they'll engage in these kinds of behavior misconduct. Okay, so dehumanization, I want to suggest, is one of the central harms of the systemic racism that leads to these kinds of incidents involving what happened to, like, for example, with Breonna Taylor. Okay, so I'm going to end quickly by, so I've talked about the harms, the nature of the racism underlying what happened with Breonna Taylor, with George Floyd, etc. What are the solutions, right? Part of the, in talking about the harms, is it can feel daunting, right? To say, oh, look at all these problems, look at what's going on. Can we solve the problem? What do we do moving forward? How do we reduce these kinds of shootings? How do we end these kinds of shootings? How do we end these things that occurred to to Breonna Taylor? And I'll just quickly, and we can talk more about this during the Q&A. The central thing, if dehumanization and the devaluation of Black lives is central to what's going on here, the solution is the opposite: to humanize African Americans, to rehumanize African Americans. That's the antidote. To treat people, to consciously work to treat African Americans as fully humans, to counter the dehumanization, to train police officers to engage, to treat African Americans as fully human. And what does that mean? One example, quick example, in Camden, New Jersey. In, I think, 2013, they abolished their entire police department and instituted a new form of community policing, where police officers were taken out of their police cars and told to, you got to walk the streets, walk the neighborhoods, live in the neighborhoods, walk the streets. Treat African Americans as the community you're protecting, rather than as the criminals you are trying to neutralize. And that has made a tremendous difference in Camden in terms of reducing these kinds of incidents. Okay, so that's, I think, one of the central themes in terms of solutions. Take steps that will counter dehumanization, foster humanization. Okay, so I'll end there, and then let's turn it over to your questions and comments. Okay, thanks.
Thank you, Professor O and Associate Dean Witmer-Rich. What we're going to do now is in a quick Q&A session, so anyone can submit questions in the chat that we will pose individually to either Professor O or Associate Dean Witmer-Rich, or both. So we're going to start now. I had a couple of questions submitted via email before the events. We can start with those, but feel free to submit as many questions as you have. So the first question is, this person would like for either of you to explain the process of how the state attorney can get away with not presenting evidence or presenting charges against the officers, and what happens now that the information is out of the state attorney, protected police officers, rather than sought for justice of the victim.
So I can address that. So, you know, the process of seeking a criminal indictment is, you know, one that we leave very much in the hands of the prosecutor. In this case, it was the Attorney General. It could be a local prosecutor. And in many states, including Kentucky and Ohio, you obtain a criminal indictment by going to a grand jury, which is a group of citizens who've been impaneled as a jury, who sit for a period of months and hear you know, presentations to the grand jury seeking indictments. So the Attorney General did take this case to a grand jury, but what we've learned What we've always known is that prosecutors are extremely influential in grand juries. So unfortunately, grand juries are, because it's a body of just ordinary people, and because there's no adversarial process, there's no judge in the grand jury room, and there's no defense in the grand jury room, it's only the prosecutor. And they're trying to decide if there's probable cause to file an indictment, charges against a particular person. The prosecutor being the expert in the room, the one with all of the facts, the police officers and so forth, has incredible control over what the grand jury hears and what they consider. In theory, the grand jury can do whatever it wants. They're not controlled by the prosecutor legally, but as a practical matter, they're very heavily influenced by the prosecutor. And so in the Tamir Rice case, for example, Prosecutor McGinty took that case to the grand jury, but we learned later that the grand jury never even voted on criminal charges. They were not even presented, and they didn't even hold a vote to say bill or no bill is what we would call it. They simply agreed, I guess, with Prosecutor McGinty, we're not going to file criminal charges here, but they didn't even vote on it. So that's how in control he was. And I suspect the same thing is what happened here. The Attorney General of Kentucky presented the grand jury with one charge against one officer for basically recklessly discharging his weapon. It did not cause the death of Breonna Taylor, so there's a minor charge that was filed. But reports are that he, again, did not even present them with criminal charges against the other officers, like the ones that Professor Paul Butler discussed, did not even present them to the grand jury for consideration and for a vote. And if he had, I think the vote would have been a no bill because he had spent the grand jury process basically presenting a case that the officers had acted in self-defense, that they entered the residence, and once Kenneth Walker fired, in what he was acting in self-defense, once he fired, then the officers reasonably believed that they were facing an imminent threat of death or serious bodily harm. And so when they fired, they were acting in self-defense. That's, I think, the case that was presented by the Attorney General to the grand jury. And again, he didn't even ask for a vote on the more serious criminal charges against the officers.
I just want to quickly add that I think is an example of what I'm talking about with the law and the required or compelled to look at the grand jury to look at the situation from the perspective of the police officers. That's what matters. That's what was prioritized. That's what was privileged. And then the conclusion was that was reasonable. And that's a problem with the law, right? And in terms of whose perspective is privileged. And
on that exact point, Kenneth Walker, he was indicted on attempted murder and first-degree assault charges. So again, the local prosecutor did obtain an indictment against Walker, even though Walker, of course, likewise reasonably believed that he was acting in self-defense. Those charges now were eventually dropped in May, I believe, but the prosecutor went in against Mr. Walker, not presenting it as he acted in self-defense, and they obtained an indictment. They went in with the police officers and presented it to the grand jury as this obviously was a case of self-defense, and so, of course, no indictment.
Right. Mm-hmm.
Perfect, thank you. Our next question is, how can we as a legal community help lay people understand or explain the legal procedure parts of how this case unfolded?
I mean, I think that's always a challenge for you as you're becoming lawyers, as you're law students now, and as you become lawyers, right? And is to try to explain to non-legal audiences things that are really important. And that's frankly part of I view it as part of your civic responsibility as a lawyer, right? That you have an ability to understand certain really important legal proceedings like this case in a way that's more detailed and probably more sophisticated than what an ordinary audience does. So I don't know how to do that most effectively, if Professor O has any thoughts on that, but that is, I think, an obligation that each of you, each of us carry as a lawyer, right, as a legal professional, try to help people understand what's going on.
The only thing I can say is, and I think Professor Witmer-Rich did a very good job of doing exactly that, to laying it out in a way that people can, lay people could understand. The key is to, I think, translate the technical into plain English, right? That, and that requires a skill. You need to understand the technical language and then be able to use the language of the ordinary plain meaning of language, the ordinary language, to convey the same ideas and concepts. Okay, so work on that, and that's what I try to do when I teach or write, is to try to talk and use as much plain language as possible, and use plain language to explain and illustrate or explain more technical concepts. And I think that's what you, as law students becoming lawyers, when you talk to people, lay people who ask questions, be conscious of that's what you're trying to do. Okay.
Our next question is for Professor O. Regarding humanizing Black persons, what legal/social societal mechanisms exist which can help us reach this goal? As a storyteller and artist, I wonder what role public art, works, theater, etc. can play in reaching your goal. I just wondered what your thoughts are on this.
Okay, good question. That's an interesting thing about art. Part dehumanization is it's a cultural problem. It's out there in our culture, not just by specific governmental actors. So to the extent art, narrative, literature can be used to humanize, I think that can go a long way towards the goal of humanization. Humanization must take a holistic approach, not just focusing on one kind of policy solution. In terms of what law can do, I think what I was saying, that if law can actually take the perspective of the victim and the person being subject to racism, not the perpetrator, that can go a long way to humanization. That is taking that is humanization. If you take their perspective, what you're saying is their perspective matters. You're treating them as full persons whose perspective matters. You're empathizing with them. Once you start to do that, you are engaging in humanization. So one example would be in the equal protection context. There's a doctrine called the discriminatory intent requirement to determine whether facially neutral laws that have a discriminatory impact on, say, a racial minority group violates equal protection. The discriminatory intent requirement takes the perpetrator perspective, focuses on the governmental actor. And that often requires empathizing and legitimizing that perspective. I've argued, and a lot of scholars argue, no, we don't need that intent requirement. We focus on the impact on the racial group, on the minority group, the law's negative impact. So to the extent that, and I think this can apply to a lot of other contexts, to the extent we can focus on the impact on the group that's being harmed, that goes towards humanization, because that requires empathy, empathizing with the group. And that's a way through law that you can promote empathy and humanization, I think.
Thank you. Our next question is for both of you. What are your comments, thoughts on the lack of serious grand jury indictments with an African-American prosecutor?
I mean, I think that one feature that this highlights is, there's not the dynamics that Professor O was talking about, and the history of white supremacy in this country is not a simplistic matter of is it a white prosecutor or a Black prosecutor? Is it a white police officer or a Black police officer? Those are important. It's extremely important to have Black prosecutors, Black police officers, and so forth. But it's not itself a solution to the problem. The problem, as Professor O described, is a kind of deep and systemic, tradition of white supremacy, in particular channeled within, our criminal process. It's definitely can be the case that individuals playing roles in those systems are one race or another, and yet they can be perpetuating those same decisions and reflecting the same problems that came before.
Yeah, I'd add that diversity is important. I think the more you have African-American prosecutors, the more likely that there'll be less dehumanization going on and serious consideration of the harms, and then you might see more indictments, etc. But on the other hand, just because you're African-American doesn't mean you are someone who will not engage in, say, dehumanizing Black lives. Okay, police officers who are trained to dehumanize criminals, African-Americans, that includes African-American police officers. They are all also trained to dehumanize African-Americans this way. So your race doesn't necessarily mean you don't engage in a certain form of racism. Okay, and that's why I think, or that's the importance of focusing on the process of racism, not just who's doing it, who's engaging in the action. Okay, because you don't want to insulate it. You don't want to say, well, just because an African-American, if an African-American attorney general said there should be no criminal charges filed, well, that must mean there was no racism, right? You don't want to engage in that kind of simplistic thinking. And if you focus on the processes going on, that you can kind of avoid that kind of simplistic way of thinking about race and racism.
Our next question, this is probably for Professor O more so, but Dean Witmer-Rich, feel free to chime in. The Karen meme has become a popular one recently. White women calling the police or otherwise trying to exercise authority whenever Black people are acting in public in ways that they, white people, don't like, whether it's driving, picnicking, shopping, walking in a neighborhood, etc. Can you explain how the problem of dehumanization is not just a problem of policing, but a problem of whiteness or white supremacy?
I think you just explained it, right? That, like I said, dehumanization is a cultural problem, and the police operate within that larger culture. Okay, and there's a culture, a history of dehumanizing African Americans that have existed for centuries. Okay, so it is not just state actors, it's people in civilians, right? White Americans, and like I said, there's self-dehumanization. There's a concept of where you dehumanize yourself. Okay, so there's some level of what they call internalized racism going on as well. So, and this goes to the point about maybe in trying to tackle dehumanization to foster humanization, you take a holistic perspective involving law, involving culture, involving art, narrative, storytelling, movies, whatever. You take that kind of approach. So for you as law students who are going to become lawyers, you never see the problem as just solely a legal problem. It's never just solely a legal problem. Okay, it's going to be, like in this case, a cultural problem. And so don't always think the only tool is the law. Okay, that is one key avenue by which these processes occur, but that's not the only one. So you are, the law can inform the way you think about issues, but don't limit yourself through legal reasoning.
Thank you. Our next question, what type of facts, for example, the way the case was presented to the grand jury, would trigger the Department of Justice to become involved in this case?
So, I mean, I think, you know, the DOJ is not going to kind of review how it was presented to the grand jury. I mean, that's a matter left to the Kentucky prosecutor and so forth. I mean, the Department of Justice can play a couple of roles. They can, you know, there's some degree of oversight if you have a pattern and practice of, you know, depriving your citizens of their constitutional rights. There can be federal investigation. And in Cleveland, the Department of Justice issued a report a number of years ago finding a pattern and practice of systematic Fourth Amendment violations by the Cleveland Division of Police. And then they entered into a consent decree with the Cleveland Division of Police to try to reform how the department was acting. So that's a broad kind of systemic approach. But I think it's pretty unlikely, you know, that we'll see federal criminal charges or federal proceedings involving this individual case. I think that's pretty unlikely. It's just not the federal government unless there's a particular unique federal interest. There's of course an crucial national interest in this case, but it's not anything unique to the federal government as opposed to the state of Kentucky. So I think it's unlikely that we'll see federal legal proceedings of any kind.
Thank you. Next question. Senator Rand Paul has introduced a bill that would effectively ban no-knock warrants, the Justice for Breonna Taylor Act. Assuming and hoping that this bill becomes law, how would this bill affect both the execution of the search warrant in this case, as well as the larger conversation about humanizing and valuing Black lives?
So, I mean, it would obviously, I mean, you know, Senator Paul's bill, he's trying to bring back some force to these ancient rules I was talking about, you know, needing to knock and announce. And I haven't looked exactly at that bill, whether it also talks about daytime entry. That's also a critical piece of what's going on here. You know, there's probably a deep tension here with just the war on drugs, right? And that has been the context in which no-knock warrants execution has become extremely common, because in most circumstances it's just not the case that law enforcement feel a need to, you know, break in without announcing. But they've developed a very deep kind of belief in the context of the war on drugs that, you know, if drugs are present, they're easily disposable. They can be, you know, if you knock and let people know, they're going to get rid of the drugs immediately. And so by the time you get in there 2 minutes later, all of the evidence is going to have disappeared. And that is the context in which, you know, I just this morning showed my class a 2018 video of a police raid by the same Louisville police officers involved in Breonna Taylor's case, executing a warrant at a home where they suspected that they were growing marijuana plants. I mean, you know, pretty innocuous criminal activity. And they approached with 2 SWAT team vans in full military gear. They ripped a metal frame door off of the hinges before they had said a word. They shot, you know, tear gas into the home. It was astonishing, right? And this is the context of the war on drugs. So I think that conversations about, you know, legalization of marijuana and decriminalization of other drugs, and not using criminal law enforcement as the tool by which we try to address the problem of drug addiction, is a huge piece of this. In addition, of course, to, you know, addressing the specific issue of preventing police from conducting no-knock warrants, no-knock raids, because they're extremely dangerous, as we see here.
Yeah, I would just add to the point about how society approaches drug addiction. It doesn't have to be you don't have to use the criminal justice system as a way to deal with a social problem like drug addiction. The problem with Oxycontin, right? That hasn't been criminalized. We don't think of that as a criminal justice issue. And so there's a choice being made by society. And this is where dehumanization is related, I think, to this, that you tend to criminalize issues like drug addiction when it involves dehumanized groups like racial minority groups. And just some statistic about no-knock searches often occur, like like Professor Witmer-Rich was talking about, in the context of drug searches, with the war on drugs. You had 3,000 no-knock searches in 81 to, in the last couple of years, 60,000 annually. That's all because of the rise in the war on drugs. And do you, in terms of disproportionality, who are these no-knock warrants disproportionately enforced against? Racial minority groups, African Americans, and Latinos. Okay, and there's this underlying it is this concept of these groups. There's something criminal about their nature, their human nature, their subhuman nature. Okay, and so starting with here's an easy solution to dealing with no-knock searches: ban them, like with Rand Paul's bill. And in fact, I don't know if you're aware, the city of Louisville did in fact ban no-knock searches after the Breonna Taylor incident. So there is that movement that is occurring, and that is one clear solution, and that will go towards humanizing people, because it's saying people deserve some simple human, their dignity to be respected by doing things like not just going in and just slamming their door down with a battering ram and just jumping in as if they're criminals, assuming that they're criminals, engaging in criminal conduct. No, you treat them with respect and engage in protocol that doesn't assume criminality.
Thank you. That was our final question from the question and answer session. I want to give each of you a chance in turn to conclude your presentations and explanations on the Breonna Taylor case.
So I just wanted to highlight first that Professor Claire May in the comments, I'm going to send out a link. She can send it to me, but I can send it to all of you. You know, in terms of the arts and humanization, she highlights Karamu House, which is a Cleveland area African-American theater group that, you know, does excellent work. And I'll send you a link to their website. And I do think that, you know, if we think of the Black Lives Matter movement, for example, I think it's, you know, you think of the art, both the visual arts, you know, the depictions of Breonna Taylor and George Floyd. We think of the really powerful, you know, film arts, the films and the documentaries that have been put forth. And of course, the legal proceedings are a component of that. But I think in the Black Lives Matter movement, it's a public protest movement. It's an arts movement. The legal proceedings are only a kind of, I mean, they are part of it, but they're only one part of it, right? That's not the primary driver. And so I think that's incredibly important. And the one thing I think that prompted me, you know, there is a place sometimes where that broader arts and humanization does kind of directly coincide with legal proceedings. And so I want to highlight that to all of you. When you are out there representing a young juvenile who is maybe going to get sent to juvenile detention, or you're representing a criminal defendant, you know, an increasing trend that is very powerful is to have lawyers, investigators, whoever, making videos that they present to the court. And the videos are not about the case, they're about their client and their client's life. And a video, for example, a small, brief documentary, right? Showing your client in their home, with their children, with their friends, doing other activities and helping a judge who is going to decide whether to send your client into detention or not. Help them get a vision of your client as a human being who exists, even if they you know, do some serious criminal activity that's going to warrant some kind of sanction. View them as a human being. And I think I would really encourage you all in your future work as lawyers to think about using the arts as a way, when you're advocating for your clients, to humanize, in particular, criminal defendants, juvenile defendants, and allow decision makers to see those people as full human beings and not limited to a stereotype that they see in front of them, maybe in court.
Okay, I don't have much to add in terms of what we've talked about. One of the central themes, like I said, is about the process of dehumanization relating to systemic racism and what we can do towards humanizing people and humanizing policies and the law. I think the one thing I haven't mentioned, that in terms of creating change, moving forward, one of the key things you can do is to engage in the political process, right? Use your voice and do things like vote, engage the political process. There's a movement happening with regards to more progressive prosecutors, people running for DA offices who are attuned to these issues regarding the problems of mass incarceration, et cetera, police brutality against Blacks. You need to go out and support these kinds of candidates, okay, get engaged in the political process and vote, right? And just Professor Witmer-Rich was saying, well, he thinks the DOJ will probably not get involved. I think the DOJ could more likely get involved, you know, if the administration changes. Okay, so that is one thing you can do. Use your voice. As lawyers, you are officers of the law. Okay, so it's your duty to use your voice and your knowledge and skills to engage in the political process to further racial justice.
Wonderful. I believe we have one hand raised. Jay Thompson, I think You can speak now, so go ahead.
Oh, no, sorry. I'm here watching with my mom and we accidentally hit the laptop, but we're really enjoying this. Sorry.
That's okay. If nothing else, I want to thank our panelists, Professor O and Associate Dean Witmer-Rich, for taking time out of their busy schedules to speak with us today. We really do appreciate your explanations and plain language explanations, especially of the Breonna Taylor case. And I also want to thank the participants for coming in today. I know it's crazy right now. Everyone has a lot of stuff going on, so really appreciate you guys taking the time to listen in. Feel free to submit any other questions to our panelists afterwards if you have any other questions about this case and future proceedings. But if nothing else, thank you guys so much again and enjoy the rest of your afternoon.
Yeah, thank you. Bye-bye.
Thank you, Taylor.
Thanks.